Today at Bearing, we are having a deep dive session on the new visa set-asides and what does it mean with respect to visa backlogs and what strategies can existing and new EB-5 investors consider in light of these visa set-asides. I'm Peter Bibler, Managing Director here at Bearing Regional Center. Today, I'm joined by my esteemed colleague, Greg Sheehan. Greg is an immigration attorney by trade, but not only that, he is a former IPO officer at USCIS. Greg, do you want to share a little bit about your background at USCIS?
Yeah, actually, I was an asylum officer first after I left private practice. I did immigration for 8 years, joined the government, spent a lot of quality time with a lot of quality people in USCIS. I'm just always honored to be a part of that team and be part of that mission. I was a field office supervisor in Houston prior to joining IPO. In 2018, where I adjudicated every form type, I was heavily involved in, the inner workings of EB-5 to some extent. I enjoy talking to people now on the other side who have these great questions about EB-5. And I love that Charlie's here because he's going to answer some of these questions that we get on a daily basis.
So for today, we're going to discuss the Reform and Integrity Act that was passed last March and how it impacts EB-5 today, specifically with the visa set-asides. And then we'll talk about visa numbers and retrogression, where we are now, what's the outlook on retrogression, and then try to address some of the market rumors in the industry and identify some effective strategies for EB-5 investors. We are a Bearing Regional Center. We have over 700 million in EB-5 developments over the past 10 years with 100% approval rating across 6 funds and helping investors from over 26 countries with their EB-5 petitions. We're excited with our current project, which is our flagship project, 1900 Broadway. 1900 Broadway is a multifamily residential tower in downtown Oakland. We are actually having our topping out ceremony next month, March 2nd, and we're expecting to begin and open the building here later this fall. And as a result, we're already more than 1,500 jobs created through the construction of this project, which would satisfy the EB-5 Greencard requirement, job creation requirement for all investors involved in this project. Today, we have very special guests with us from the WR Immigration, Wolfsdorf, led by Bernie Wolfsdorf, which is a household name in the EB-5 industry, former president of American Immigration Lawyers Association. And today, joining us, we're very honored to have Joey. Joey Barnett is a partner here at WR Immigration, experienced for several years in EB-5 and all aspects of immigration. Joey, do you want to share a little bit about yourself and your experience at WR?
Sure. Well, thank you so much, Peter, Greg, for having us here. It's great to talk with you guys. My name is Joey Barnett. I'm a partner at WR Immigration. I've been practicing in EB-5 for 12 years now. On various committees in EB-5. I sort of eat, sleep, and breathe EB-5, and it's wonderful to work for WR Immigration. I've been there for 6 years, and just recently we got a new hire, Charles Oppenheim, who is here with us today, and he is our Director of Visa Consulting now, and he used to work for the Department of State for, I think it was 4 decades, right? And in particular, he was the Chief of the Immigrant Visa Control for, I think, 23 years. Is that correct, Charlie?
Yes, it was. 23 years.
He knows the inner workings of the Visa Bulletin and the Department of State and how they calculate and allocate immigrant visas. I've learned a lot from him, and it's great to be here with everyone. We are a full-service immigration-only law firm, and we have 9 offices, over 200 employees, over 40 attorneys. We represent big multinational companies, smaller companies, universities, educational research institutions, and we're also very big in the EB-5 community as well. We have filed over 3,000 I-526 petitions. Bernie did his first EB-5 case in 1993. We have a great team of professionals on the EB-5 team, and in terms of litigation and policy, Bernie is always kind of pushing the line with regards to policy, whether it is direct communication with USCIS through the American Immigration Lawyer Association, or more recently through judicial intervention and trying to get USCIS to change how they act through lawsuits on behalf of investors or regional centers. It's been a great honor to join Bernie on this venture. Really, really happy to be here.
Joey, Charlie, we're very excited to have you both here. You guys are experts in your field, and we're looking to forward to having some deep insight. This is an opportunity. A lot of EB-5 investors have a difficult time trying to get access to good, clear information, and there's not a lot of quality sources out there. The internet has a lot of noise, and so we're just hoping to use this opportunity to sift through that and take a deep dive, as we say, into these issues, and hopefully provide some clarity going forward. Now, I guess we'll just jump right in with that. Greg, perhaps you can kick us off. We'll talk about the Reform and Integrity Act, which was passed last March and which created visa set-asides. And so if EB-5 investors are looking at the visa bulletin, which is kind of what we're focusing on today, it looks very different than it did in years past. So Greg, can you kick us off here now?
Yeah, agreed, Peter. The game has changed in a lot of ways, but it still requires an investment that creates jobs. But now there's different opportunities, what are now set-aside categories. So the visa bulletin used to be certain size matrix, and now it's almost doubled. So Charlie, tell us what's going on. What are these set-asides?
Well, with the passage of the bill, there is now rural area, high unemployment, and infrastructure reserved categories. For the three, they get 32% of the overall employment fifth preference annual limit, with the remaining 68% going to unreserved categories. Primarily the cases which had been introduced before the bill was passed in March of 2022.
So when you're looking at these, does an investor have the opportunity to try to file within more than one category to try to create some advantage? And how would that actually work at the visa level?
I think just as with any type of immigrant visa category, applicants can file for as many as they may be qualified for, but it would be best to get information from your attorney who is handling the case, or talk to others regarding which category would be in your best interest to file so that you could maximize your chances at a visa in the most timely manner.
So who would make a decision if there was like a tie to be broken?
Right now, I think that the best opportunity would be for somebody that was filing in the rural areas, which is entitled to 20% of the overall, the new limit, because these categories are just starting out. So if somebody were to file in the rural processing area now, they would be at the very front of the visa processing line for that category.
And one of the things that comes with the idea of rural is the idea of priority. Do we know what that means?
That I will defer to Joey on that.
No, we don't. We don't know what priority processing means. The legislation does indicate that for investments in rural areas, they are supposed to get priority processing. USCIS hasn't come out with any guidance yet. It doesn't seem like we'll be hearing anything about that. But in terms of who this benefits most, these rural high unemployment and infrastructure set-asides are really for folks who would have been in a serious visa backlog had these visa categories not been created. In particular, Chinese nationals and Indian nationals. And so because these are current right now in the visa bulletin and for the foreseeable future, that creates a really great opportunity to do EB-5 and to even file an adjustment of status, where before this time last year, that was not an option. So that is the new opportunity that is available with these visa set-asides, and why we're seeing so much interest right now from folks in the United States in particular on H-1Bs or F-1 visas, where they can take advantage of this new concurrent filing process as well. So it's a double whammy, so to speak, of opportunity. The other great thing about these set-asides is it qualifies for that lower investment amount as well. So not only do you get the set-aside, you get the lower investment. I think the timing of the visa bulletin, I think that is the big key, is how long is it going to be current? Because that's the opportunity that folks have.
Right. I believe that all of the new reserved categories will stay current throughout fiscal 2023, and most likely stay current until probably well into the second half of fiscal 2024. The reason I'm saying that is based on typical processing times of petitions which are filed with USCIS. I just don't see how there would be enough applicants with approved petitions in these new rural set-aside categories to require the imposition of a final action date, like I said, probably before the second half of 2024, because the only reason a final action date would be imposed if the demand for numbers exceeds the amount available under the respective annual limits.
Now,
Let me peel back a layer on that, because we're hearing around the industry that there's probably more filings than there are, let's say, in the 2% category, but things remain current. So you would think that demand is elevated, but at what point is a final action date actually determined?
Well, as I said, the State Department will look on a monthly basis when they're making the determination of the final action dates. And based on the amount of demand which has been reported to them, they'll compare that with also considering the amount of visas which have already been issued in that category versus the annual limit for the respective category. And as I said, only once the amount of visas which have been issued and the amount which they estimate will be issued within the coming months, only when that exceeds the amount available would they need to impose a final action date. One of the key things is for the USCIS offices to post timely and accurate information so that the industry kind of can gauge what the level of demand is in each of these three new reserved categories and the rate at which the approvals are taking place. Until that information is available, it will be somewhat hard to pinpoint exactly when a final action date is likely to be imposed.
Is it fair to say that you need some adjudication progress to actually do this math and make projections?
Yes, you need much more information than we currently have. And that's why I say, based on the information we have available at this time and the historical processing times by USCIS for the approval of petitions, that is why I say I just don't see any likelihood of final action dates being imposed prior to the second half of fiscal 2024. And if the industry is lucky, maybe not until the very end of fiscal 2024. But as you mentioned, I think that the infrastructure category, where it is only a 2% limit, I think that is likely to be the area where we would see the first introduction of a final action date and potentially also an application filing date, which may govern which applicants can file well in advance of their turn being reached.
When you were referring to these final action dates being imposed in sometime in mid to late 2024, fiscal year 2024, are you referring to final action dates, country-specific final action dates? One, maybe we should step back for the sake of the viewers, that there is a country cap in each category, or generally speaking, in the EB-5 category. And then the question becomes, is there a country cap within those individual limits? And here in 2024, fiscal year 2024, would we see final action dates specific to individual countries or for the entire reserved category?
To your first point, yes, there is a 7% per country limit which is imposed, and those 7% per country limits would also apply to the amount of numbers available in the unreserved categories and each of the three reserved categories. So that will be a limit that will govern when the final action date may need to be imposed or an application filing date. And I think this is another area where, again, we need reliable and timely data from the Immigration Service to determine, are there certain countries which are dominating the filing of petitions in this category? Since the categories have opened up to all basically at the same time, it's going to be important to see the distribution among the various countries. And again, to be able to accurately predict when and if dates may be required for certain countries. Historically, the countries which you would be watching most closely would most likely be China, India, Vietnam, Brazil, South Korea, the typical ones that were dominating number use under the pre-establishment of the reserved categories.
Let me just butt in here and kind of explain the sort of the overall lay of the land, I think, on this and what it may mean for a prospective investor. Right now, the visa bulletin is current for these reserve visa categories because the Department of State hasn't received any indication from USCIS that there have been I-526 approvals for those reserve visa categories. And so because of that, there is a little bit of a lag time where an investor has an opportunity to file an adjustment of status because it is current at the same time of filing the I-526 and getting that EAD card and advanced parole and the right to remain here, even if, let's say they're let go with the H-1B or they finish school and they're done with the F-1. The benefit of having a current priority today is you get to file the adjustment of status. The benefit regarding your I-526 petition is when your I-526 is approved, is your priority date also current? That will allow them to actually approve the adjustment. So there is a little bit of a difference here. And something that I think is always a little bit confusing is it says it's current today when I file. Does that mean that there won't be a visa backlog in the future? The answer to that question is no. It doesn't mean that. And the visa bulletin can change over time to reflect any increased demand that isn't reflected in today's visa bulletin. I think that's something that is a little difficult to understand because there's just this lag of data. And in particular, with USCIS processing times for EB-5 so long, I think that's why Charlie's projecting these final action dates in fiscal year 2024 is just we don't know if there will be data from USCIS by then. Is that right, Charlie?
Yes, it is. That's an excellent point. And the key there is the final action date that may or may not be listed in the visa bulletin when final action on an applicant's case is possible is what governs whether they would be issued a visa if processing overseas or adjustment of status in the U.S. It's that date in 2024 or 2025 governs whether they can be finalized, not the date now that they're filing. So it is very important to, like you said, to file. But this new concurrent filing law is a unique, very unique opportunity, which was not available to many applicants, primarily Chinese applicants in the past, who had processed their cases overseas in Guangzhou. Now they'll have this opportunity to file for adjustment of status because the categories are current now and will be current for the foreseeable future.
So let's say it's 24, 25, we get a date and everybody says, all right, it went from current to date X. It may retrogress by a certain amount of time that we can't predict. So Joey, at that point, if somebody who's a new filer who's not in a current visa availability category, if they try to file concurrently, would their EAD application be adjudicatable or no?
If it's, well,
if
that's
they're
where
no
we
longer
get
current.
in, if they're no longer current under both Chart A and Chart B,
Right.
we'll say that in the visa bulletin, well, then they would still be able to file the EB-5 application. No problem about that. But they wouldn't be able to move forward with the adjustment of status at that time until the visa bulletin advanced, until the 526 priority date became current. And that priority date is the date at which USCIS receives your I-526. I guess one other question I would have is, Charlie, let's say it is the second half of fiscal year 2024. What would you suspect, at this time with incomplete data, that the date would be? What do you think that would be imposed at? Do you have any thoughts on that?
Unfortunately, without the data being released at this point, it's hard to say, but my guess is that it would be sometime in 2023 would be when the dates are initially established. And again, the good thing is, I think that your first indication that large amounts of demand have been, or applications have been received and are being finalized will be when application filing dates begin to be listed in Chart B of the visa bulletin, because the Chart B dates in the visa bulletin reflect where the State Department believes the final action date will be in approximately 8 to 12 months. And the reason is the State Department and now USCIS uses that Chart B data to allow applicants to begin filing their paperwork at a much earlier point so that, like I said, 8 to 12 months down the road, when they believe the visas will be available, all the pre-processing on the case will be complete and they can get their case processed immediately. And that, again, that's why people should monitor the Chart B dates, and that will give an indication of when that state believes final action dates may be imposed at some point in the future.
One thing I want to talk about related to these visa set-asides that have some impact on your predictions for the final action dates is the carryover of unused visas. And I think the first question is do we have a sense of, the new visa set-asides were implemented in after March 2022. And I guess first is just to understand, where are we in terms of visa numbers? Do we have an estimate on visa numbers for these visa set-asides for EB-5? And would like to understand, what are the rules? What's the process of these carryover of unused visas? Because we're assuming with current processing times, few, if not any, are actually being approved, since March, since people started filing after roughly July, August of 2022.
With the carryover of numbers, last year there were several thousand numbers available in the reserved categories. None of those numbers were used. So all of those numbers that were available in each of the three reserved categories carried over to this year's respective categories. And to give you an example, this year's annual limit approximately in the rural set-aside category is approximately 6,800 numbers. And that includes what would have been available under the normal fiscal 2023 limit and the amount that were carried over unused from the past fiscal year. And this is a very unique situation began with the passage of this bill in March. And historically, if numbers were not used in the fiscal year they were originally available, they were not carried over for use in the next fiscal year. They potentially fell up to one of the higher categories for potential use in that fiscal year. So this is a very unique opportunity. And again, it is a very good thing for each of these three reserved categories, providing them potentially with many, many more numbers than they would otherwise have available.
Because there is that increased supply, there are less likely that a final action date would be imposed because there are more visas available. Is that accurate to say, Charlie?
Yes, it is. And again, if there was accurate data available now, it could be compared with this year's annual limit, for example, in the rural category, 6,800 numbers versus the amount of applicants who have already filed a petition in the rural set-aside categories. And it's important to remember that each applicant in a case, the principal and any dependents, count against the annual limit.
So do we have a sense of...
But again,
and when you say rural,
HUA?
It's really high unemployment,
Yeah.
rural, and infrastructure. They really, all the same principles hold through. It's just the different percentages of that are reserved, but the same principles hold through for each. It's like one of the things that, we were all in Miami at the EB-5 Investors Conference, and, we're trying to get an understanding of, well, how many cases have actually been filed, right? Because USCIS hasn't reported this data, and it's kind of among us to figure it out, because that really will impact the lines and the possibility of the imposition of a final action date. A lot of chatter and a lot of interest. I don't think anybody knows how many cases have really been filed. So it's tough to say, this line is faster than that line or something along those lines. It's tough to say. We don't have the numbers yet. I don't think anybody does. Right. So at this point, in that sense, there's a fair amount of marketing puffery or guesswork in play. Just want to be very clear about what I see and what we actually know. In terms of, Peter, your question of, do we know that the State Department has actually read the EB-5 law? The answer is yes, because in their annual report, they did separate out, in terms of visas issued, their different reserve visa categories. And they said that 0 of these visas in these reserve categories were issued. They have separated out those 6,400 or, approximately 6,400 reserve visas from this past fiscal year. And those are available in fiscal year 2023 for use. And if there isn't demand for use in the reserve visa category, well, the legislation also gives DOS the authority to use those on the unreserved visa category. And that hopefully will be used there because we know there's demand there, and that will help reduce the backlog to existing EB-5 investors, in particular, Chinese mainland investors who have those really early priority dates and have been kind of stuck. This is good news for existing investors who want to take it, or excuse me, for existing investors who have been stuck, and for prospective investors who kind of want to take advantage of this unique opportunity, in particular, if you're here in the United States and can do a concurrent filing application. That is, I think, the real key. Yeah.
Yeah. And to Joey's point about getting with the industry to try to figure out roughly how many cases have been filed based on the rural limit for this year and the carryover numbers of approximately 6,800 numbers available. If you assume that there's 4 applicants per case, that would allow over 1,700 cases to have been filed and be processed to conclusion under this year's annual limit. Have there been 1,700 cases filed? That's anybody's guess at this point. And that would be a minimum.
How does it roll over each year? And is there a limit as to how many times it can be rolled over? And as Joey was referring to earlier, is there authority for the State Department to take those early without having to, when at what point in time are they authorized to apply it to existing retrogressed unreserved visas?
Any of the reserved numbers which were not used during fiscal 2022 carried over, as I said, and were added to the fiscal 2023 respective limits. If the State Department determines that those numbers carried over from 2022 will not be required for visa issuance or adjustment of status during fiscal 2023, they can then make those numbers available to applicants in the unreserved category, and they could begin to do that at any point during the year. I would typically look at that type of issue when I was making the determination of any of the final action dates, whether they be family categories or employment categories. And I would try to make that determination as early in the year as possible so I could just start distributing the numbers early to ensure the maximum amount of time for the processing to occur and therefore not waste any numbers. And another reason for doing that early is if any of those fiscal 2022 carryover numbers remain still available unused at the end of 2023, they disappear. The carryover numbers only carry over for one fiscal year, and that's it. That is one of the unfortunate things for the processing now, that the fact that it takes USCIS a considerable amount of time, there are unlikely to be enough reserved category applicants to utilize all the numbers available this fiscal year, which is unfortunate for them. But as Joey said, this is going to be a very exceptional year for applicants being processed in the unreserved categories.
So,
and in moving forward, until there is the demand and use of the reserve visa numbers, every year's will get rolled over into the next fiscal year, and they have to be used in that next fiscal year or they're gone. So I think the real challenge, is maybe some administrative stuff within the Department of State, is when the reserve visa numbers start getting used, the question is well, are they this year's visa numbers or are they the carryover from last year? Because that will impact whether there will be more wasted visas or not.
Right. And the most reasonable way to look at this process would be to consider the 2022 carryover numbers to be the first used in each of these 3 reserved categories so that no numbers are wasted. That way, if there are unused fiscal 2023 quote original reserve numbers, then they can be carried over to fiscal 2024 for potential use, when there may be many more approved petitions allowing the actual number use in the respective categories.
Hey, Joey, let me jump in here. What's Bernie's take on the idea that there could be visa waste based on administrative delay? How does he feel about that idea?
He thinks it's happening all of the time. And in particular, if the State Department doesn't process these carryover quickly enough, then there will be wasted visas. That is a fact. We have litigation going right now against the Department of State to try to push that line for the unreserved visa use. We believe there are, just statistics in their own data reports which seem to indicate that they didn't use all of the available visas last fiscal year, and hopefully we'll be able to use that to try to get some relief for some of our Chinese plaintiffs who have, with 2015-16 priority dates, who have been kind of languishing as the visa bulletin hasn't pushed that final action date forward. It's kind of gone back and forth a little bit. And so I think, what does it say? Maybe by January 2016 was that for Chart B? I think that's what it is. So
for China, the application filing date in Chart B is January 1st of 2016. So that's where the State Department believes the China final action date will be no later than September of this fiscal year.
And that considers I'm just trying to think, are they considering the use of these carryover in that determination at all?
I will speak from when I was chief of the office controlling it. I would have considered that, yes, because I would want to be allowing people to file now, because it takes, if I were to file at a district office or file with USCIS today, my case is unlikely to be ready for final action at that office, probably for maybe 6 months. So I want people to be able to file as early as possible in order to maximize number use under the current year's limits. And to your point earlier about, quote, wasted numbers, there were probably 5,000 to 6,000, quote, wasted numbers under the unreserved limit for last fiscal year. And those unreserved numbers that were not used last year, they are lost to EB-5 applicants. It's only the reserved category numbers that actually carry over from one year to the next.
It seems to go against the intent of Congress, who put this program back together to put it on these rails. But now what's left in the dust are opportunities for potential investors who are putting their money to work for us.
Well, there are also options. Sorry, I don't mean to, let's say that you're an existing EB-5 investor. The money in your initial project is coming due, and they're coming back and saying, hey, do we have your authority to redeploy your money? And potentially what you could do there is not redeploy your money, get your money back, add in $300,000 more, get in a new reserve visa line, and potentially get your green card faster that way than if you have, say, a 2017 priority date in the unreserved China. That is an option for folks who are in that backlog and have that additional available money. Sorry, I didn't want to.
No, that's a good question. I mean, could somebody do that anyway before getting the $500K back? It would require another $800K. I get that, but is that legally possible?
You mean to file a new I-526 petition with new money in a new reserve visa category?
Right.
Yeah, I don't think there's anything stopping anybody from doing that. It's just having another basis by which you can obtain a green card, and it's in a different visa category. Charlie, would you agree with that? I don't think there's anything wrong with that.
Yes, it is. And like I said earlier, I think it's important for applicants to file in as many categories as they qualify for, and then whichever comes available first, it would be your, so
right.
Yes, I would be filing.
We had a client who filed, who was in the existing EB-5 line, 2017 filer, and he was fortunate enough to be able to file in a high unemployment area. So he filed there, and he also filed in a rural project too there, because he just didn't know which line was going to move faster, because we just don't have the numbers. He wanted as many options as possible, and that's exactly what Charlie was just saying. It's get your, if you have the ability, especially with EB-5, because really it's just about documenting the source of funds from the personal side of things. And if you can do that, then you do have multiple options available for you, different lines to sit in.
That does bring up a question. I have like a very specific question. You look at the new I-526E form, and you can check the box of which category you are selecting. and it says choose all that apply. And conceivably, you could check all 4 boxes. Practically speaking, you could have a high unemployment urban project or a high unemployment infrastructure project or an infrastructure project that's also a rural project. So either by design or it's an oversight, but the investor and their filing attorney could conceivably check off all 4 boxes. So who makes that decision, and how do you think that will be made? If you have any insight on how that might be made, Greg or Charlie or Joey, do you have any insight of how that selection will be made?
That's a good question.
Greg may be better off doing this, but a determination, I would believe, has to be made in which of the 3 set-asides the applicant is going to be ultimately processed. Because, and I'll give you the example under the unreserved categories. There's the C5, the T5, the R5, and the I5. When the petition is approved, one of those 4 designations is applied to the petition, which is then forwarded, if being processed overseas, is forwarded to the State Department. And the State Department would consider that application against the limits which are imposed for those various categories. And that's the only way you can determine, is there too much demand in the rural or the high infrastructure or the high unemployment or the infrastructure? You need to know how much demand is in each of those before you can say, okay, there's more demand than the amount available. Again, you need to have that distinction of demand and the priority dates associated and the foreign state of chargeability associated with that petition to determine when and if you would need a final action date for a country or a specific category. The other issue is they need to decide category identifiers for each of these, the rural, the high unemployment, and the infrastructure. Has that been done? That I don't know, but it is a very important thing. Again, like I said, for when the case ultimately resides at the State Department or USCIS for final action.
Yeah, it's easy for the old 526s to get coded in because it's either TEA or it's not. But now with the 526E, if you have multiple options, you don't want to just have somebody like me make a decision on which one it goes into, or that's arbitrary and capricious. You need to spell this out to the investor class so that they have awareness of where you're going to get put if there are 2 available options. That's my thought.
To answer the initial question, it's USCIS makes this determination, not the Department of State, of which reserve visa category it's in. When you check multiple boxes, I think it is conceivable that you could have a high unemployment and a rural, right? And you click both of them. And how they code it, the Department of State is going to defer to USCIS's determination. And I know this because we had a direct EB-5 investor who was stuck at the consulate level during the regional center lapse, and because it was coded incorrectly. And the Department of State said, hey, we can't do anything about this. It has to go back to USCIS. They have to recode it, then send it back, and then we can schedule the interview. Like the Department of State, this was in litigation. We had litigated about it because we said, you do have the authority to issue this visa. They were saying, no, we don't, because it's a regional center case. And we're saying, well, it's not. It was just coded incorrectly. So I thought that was sort of interesting that it really is up to USCIS. The only other thing that some people have asked me about is, well, what happens if a reserve visa category gets backlogged? And this is I would say a non-Chinese, non-Indian, where it would get backlogged in the reserve visa category, but it's not backlogged in the unreserved visa category. Could you switch it then? Well, if it's in the unreserved visa category, then you have to invest the additional $250K. And so I don't think you would qualify, if you were trying to meet that as well. I mean, I guess you could have a rural investment at one point, or, at that higher investment amount. But I think most of the projects wouldn't qualify at that. But I think in terms of the reserve visa category, that is an issue. I haven't seen that come up yet, but I can foresee it happening for sure. And USCIS
you mean
is
like
going to
adding
have a plan.
$250K after the filing to try to change the category?
Yeah, I guess that could be, but that may also require, the project documents to get modified and things like that as well.
It's going to have an issue because at the time of filing, it was $800K, and that's what they're looking at.
Exactly. So I think that would be a tough argument to make.
And the problem with that is the case would have to be, re-adjudicated. Is it going to go back into the back of the line of cases being processed currently or not? That's one of the questions, is how is USCIS processing these new petitions under the 3 new reserved categories? Is there a separate line for these processing? Are they at the back of the current line? So again, are there 2 lines being processed, a single line being processed? Are these cases being expedited? Are they going to be processed at a faster pace than previously filed petitions in the EB-5 category? This is, one of the issues, what people may claim is slow processing of petitions in the early stages of the EB-5 program resulted in many of the backlogs of applicants we currently see is because petitions were not being approved in a timely manner when there were sufficient numbers to allow processing of all those cases. And we're seeing that right now. If a case was filed sometime late last year, all the categories were current, yet none of the numbers were used because they weren't processed. That may have been unrealistic in terms of a short processing fuse, but as we get to the end of fiscal 2023, when there would have been at least a year since filing, could there have been higher rates of processing occurring if cases were adjudicated at a faster pace and approved?
Yeah, I think one of those things where at this stage, if you believe you qualify for multiple reserve visa categories, check all of the boxes that you think can apply, have the evidence in your I-526 petition to back up meeting both qualification. And it's sort of, we're going to have to see how it plays out, but get ready to make the argument and potentially expect a little bit of bureaucracy until the government figures it out. But I think just by a plain reading of the law that it's definitely allowed. It's just we have to kind of see how it's going to play out. In terms of, no one, I mentioned before there's a little bit of a lag, right? And there is the possibility that a final action date is imposed in the future, like Charlie foresees. There's no science, there is a science to it, but no one has the data yet for us to really be able to complete the formula. And so the advice that we provide is the earlier you file, the more likely it is that you are not going to be stuck in a backlog because it's based on your priority date when you file your I-526. And I know that's not the best thing to hear when you're going to be investing a lot of money and it has to be at risk. But anybody, I think, who tells you differently, those are the facts that we have. There are knowns and there are unknowns. Our job as immigration attorneys are to provide as much information as we can so that the investor can have an informed decision. There are just some things out there that nobody knows. And look, we got the former chief from the Department of State saying there are just unknowns. And so you can believe it here. There are just some things that are difficult to advise on. And so that's why our advice is file early and file in as many categories as you can to give yourself the best option. So let's say you file, right? It's current today. You're an Indian investor and you did high unemployment area investment and it's now March of 2025 and there is a final action date that has been imposed, right? And let's just say, okay, if you're before that final action date, well, then you continue to move forward as if it was never imposed in the first place. If you're on the date or after, well, then you still can remain here lawfully because you have your adjustment of status pending and it remains pending. You still have your EAD. You still have your advanced parole. You can still file to extend those. And so I guess on a pause, but you're here in the United States and you're able to work and you're able to travel. So you're still getting a pretty good benefit from filing now when it is current, even if there is a future imposition of a final action date. That is an opportunity that you would get at this point.
I want to pick up one of those points there. So let's say that you have filed today, you need to extend your EAD and advanced parole, you're in a backlog situation. Can you still have your EAD renewal approved and your advanced parole renewal approved?
Yes, you can. Your adjustment remains pending.
Perfect.
They just aren't able to take final action on it yet until the priority date is current.
And
that's what happened a lot when they opened up Chart B back in, was it March of 2020 for Chinese investors? A lot of folks who were in the United States at that time did adjustment of status. They're still not current. Their adjustments remain pending, but they're able to continue to do those renewals and to be here. So yeah, it's a huge benefit.
So while everybody's current, there's no limit to how many people can apply for EB-5.
Correct. Well, there's never any limit on how many people can apply and do I-526. That's for sure.
Right. Be able to get that concurrent.
But yes, while it's current, you can do those concurrent filings for those investments in those areas. Yeah, absolutely. I mean, when the concurrent filing option, came up, it kind of like, I think it took the EB-5 community a couple months. There were like new price increases and these reserve visa set-asides. But like this concurrent thing was like just a few lines in this 117-page legislation. And it was like kind of glanced over at first, but it is a huge, huge game changer for EB-5.
On this topic of just giving the example of an investor filing now, many of our viewers are in the H-1B camp. They're already here on the United States or they're on F-1. And just looking again at the overall visa numbers, we've been talking about visa backlogs specific to EB-5, but many of these H-1B folks in the United States are looking at visa backlogs in EB-1, EB-2, EB-3 categories, and they may already have priority dates for those, but they're still stuck in backlog. So one question I wanted to highlight, if we have any estimates on how long someone's looking to get a green card through the EB-2, EB-3. Do we have any estimates if they were filing now? It's obviously these guesstimate work or speculation to some extent, but roughly like how long it would take to get a green card comparatively through an EB-5 in a reserved visa category. So the first question is, what are these backlogs, like the timing of these backlogs for the EB-1, EB-2, and EB-3 categories for Indian H-1Bs and Chinese H-1Bs where they're facing these backlogs?
I think that it would be interesting to know the amount, if there's been a large increase in the amount of EB-1 petitions being filed for countries other than India and China. Because in the past, the amount of numbers available to, and I'll call them rest of world applicants, the amount available has far exceeded the amount required. And that is why the rest of world EB-1 has normally stayed current. If there's any unused rest of world numbers, those numbers can be then made available to China and India, because unused numbers under the overall limit are made available strictly in priority date order without regard to the foreign state. And that is what allowed EB-1 to stay current for extended periods of time. And now there is a China and India final action date for employment first. I think that it is likely that that date, if it moves, would move ahead relatively slowly, because the State Department, there is enough demand for China and India employment first preference applicants that state can wait to make a better determination of the actual amount that will be required by the rest of world applicants, and still late in the fiscal year make any of the unused numbers available to India and China and still use the overall employment first preference limit. So there is no harm. Like I said, they have the cases ready to go. They could be processed if they didn't move the date significantly until the summer months. They could still easily use all the available numbers. I think that the fact that there is an employment second preference rest of world final action date means that the India employment second preference date is not likely to move at significant rates. And because in the past, the India second preference has been able to benefit dramatically by significant amounts of otherwise unused numbers being available. That is because the rest of world category was current. As long as that category is not current, then I don't think you're going to see significant movement in the India second preference date. The one positive thing with the current India second preference date is that the State Department may have established that as kind of a, quote, line in the sand, that they could see what the incoming demand is like by applicants with priority dates earlier than that date, and then slowly start to move it ahead in the future, again, because they know they have significant amounts of pending cases and can maximize number use by moving it later in the fiscal year. And in the third preference, I think that the India third preference date, while it may move, it will not have the significant movements it has in the past. And it is very important for everybody to remember that we have had very unique situation in the employment limits because of the COVID for the past several years. The last 3 years, the employment overall annual limit has been at record highs. Last year's 281,000 for fiscal 2022 was an all-time high. The year before it was approximately 262. This year it's down to approximately 197. The great strides in movement of the India dates and the China dates that were available in the past 2 years are not going to be seen in the future. Unfortunately, some people got used to the significant movements in the past 2 years. Those are not going to happen in the future.
So I have a question about that. In the second category, third category, we saw a movement with that big number of visas available. We saw a movement come up from 2011, 12, 13, 14, and like upwards. Based on the number of visas being made available, is it going to move forward, and at what pace? Is it going to be 65% slower? Like, I'm just trying to forecast how far we might see this go in the next couple of years.
It's hard to say. I am sorry to look down to read off something, but I'm just going to give you an example of the situation. In fiscal 2019, the last full fiscal year before COVID hit, the India second preference only used 2,900 numbers, or used approximately on a worldwide basis, 2,900. In fiscal 2021, they used over 28,000 India second preference app numbers. So you went from 2,900 to 28,000. The data for 2022 is not available yet. My guess is that India's second preference probably used well over 20,000 numbers again in fiscal 2022. That is not going to happen this fiscal year. It is going to be significantly less than that.
From an EB-5 immigration attorney point of view, I can say that literally every day for the past month, I have had calls from someone here, Indian national in the United States, with a with an I-140 priority date, looking at EB-5 as another option because they just don't see that moving forward fast enough for it to make sense, in particular if they have children who could potentially age out based on that. EB-5 has become, in particular because of the concurrent adjustment option, has become a huge sort of contingency plan for a lot of folks in the United States who've made the United States their home, it's their children's home, and they can't see a future anywhere else. And they're just looking at the slow movement. They looked at the retrogression. They see the numbers that Charlie talked about. That's actually great progress to see. I didn't know those numbers, but I mean, it's crazy to think that they did 10 times the number of EB-2 visas for India. That's not something you always hear about. You hear about the other side of it, that they're not going fast enough, that there's too many people languishing. But, it's kind of nice to see the data to see, well, actually, they really did do something with this bumper crop of EB visas. It's reassuring to see in my eyes.
And to the Immigration Services credit, typically at least 85% of the employment numbers available each year are processed in the United States with adjustment of status cases. So one of the things is that because there was such large amounts of the India second and India third preference applicants, quote, in the backlog that had cases pending that had filed many years ago, those cases were able to be processed in order to maximize number use last fiscal year. And again, there will be this fiscal year. They kind of had that ready-made pool so that by advancing the India second and India third preference, not quite as much as the second, but by advancing those final action dates, they were able to tap into that pool of, quote, ready to go cases and maximize number use. And again, as I said, there is that pool still out there that allows the State Department to wait until much later in the year before making dramatic moves in those categories and still be able to maximize number use.
Would you estimate then that it would be a faster path, EB-5 would be a faster path to obtain the green card for a person with a I-140 priority date? How far back would we go? 2015, I guess, for example. We get a lot of calls from people that, have I-140 priority dates as early as 2015, still looking at this EB-5 as an option. Partly, in some cases, like Joy, you mentioned, age out concerns for children and such. Would EB-5 at this point be a faster path to obtain a green card?
I think if I were an Indian applicant and I was filing a petition today, if I had the choice to file in India second or India employment fifth preference, I would choose the employment fifth preference, assuming that I would be processed years faster than I would in the India second preference category.
Yeah, to me, that's a no-brainer. If they're both here today in 2023, that's a no-brainer. I agree it gets more difficult as you go back in time. The data is tough to say, but I think you're right. Anywhere around 2014, 2015 is kind of when you start to say, well, maybe. But if someone right now is thinking about it and they see the EB2 India today is October 2011, right? So and I see that in chart B, it's only May of 2012. So by September of this year, it's only going to move to that date. And you see that the number of visas just available are going to go down because the annual limits are going down. And it's going to start getting to these lower numbers of maybe 2,000, 3,000, whatever it may be a year. And you just see how many people are in demand. You can do the calculations and you'll see that if you filed in 2014, 15, I think it's going to take some time. 2016, 17, to me, it's still a no-brainer. EB-5 is going to be faster. It's as you get kind of closer to where it is, further back, that's more of the question marks. I haven't done the math yet really to do that, but it's also these visa bulletins are difficult because the numbers can change based on age outs, based on maybe someone does a downgrade or whatever the case may be, and the numbers can change. It's fluid. It's not something that's static, and that's, I think, one of the hardest things to try to understand when you're setting your life and your family's goals in future based on these calculations. It's tough to do.
Yeah, I was just going to say that if somebody's priority date is 2 years away, it doesn't mean their wait is 2 years. It's easy to look at it and tell your family, no, it's just 2 more years, but it doesn't work that way.
Yeah, and because of the growing amount of applicants that are filing petitions, again, I go back to the rest of world applicants other than Chinese and Indians that are filing in the first and second preference and the third preference category. There's much higher demand for numbers versus the limits, which will, starting in fiscal 2024, the employment limits are going to go back, I would say, to approximately 150,000, which are dramatically versus 281,000 last year, 197,000 this year. The amount of numbers available to Indian and Chinese applicants is going to be far fewer in the future years than there are currently. This is another draw to the EB-5 program at this time if an applicant could avail themselves of it.
One of the questions I get from people overseas is, we talked about this before, Joe. It's like somebody likes concurrent processing enough to try to figure out what type of visas they could use to come into the United States. And I'm not talking about B, but what are the options? E2, L1, student, how does it all work?
It's a great question. And there's this concept of immigrant intent. Some visas, when you come in on and you try to get a green card, you have immigrant intent, the intent to make the United States your home country. You're going to be here permanently. There are some visas out there, like a student visa or a visitor visa, where you're supposed to have non-immigrant intent when you both apply, when you enter. And that means that it's supposed to be for a specific purpose and that you intend to leave the country at the end of that purpose. Right. And that's either indicated on the stamp that you get when you're processed by the officer at the airport, or if you're a student, you're going to have a duration of status. So as long as you continue to go to school. There are some visas, though, which are called dual intent visas, like the H-1B or the L-1, where you can still have immigrant intent to make the United States your home while coming in for this specific short-term non-immigrant visa. And so I would always first try to look at an H-1B or an L-1 if you're out of the United States, because those are clear dual intent visas. E's and O's are sort of quasi dual intent visas, as Bernie likes to say. Every case is different. It really can depend on what your true intent is when you're coming in. I would say H, L, E, and O are the types of visas that you would want to look at as a way to potentially come into the United States and try to get through EB-5 a bit faster with the concurrent processing. Now, of course, we can't and don't encourage visa fraud or misrepresentation or anything like that. And you have to talk with your immigration attorney about the right way to do this, because the consequences are severe, right? If they catch you for misrepresentation trying to come to the United States, then you're barred for life, right? So a huge deal. This isn't something that we take lightly. We are a very conservative firm. We generally will not advise folks to come in with a visitor visa with the intent to adjust. Like, that's a big no-no. There are different rules in place, whether you're dealing with the Department of State or USCIS, about how they look at your actions, whether it is actually taking steps to file an application, or just, hey, if you're like enrolling your kids in school in the United States and you're opening up a bank account and trying to get a driver's license when you've told the government that you're only coming in for 10 days to go visit Disneyland, it doesn't look good. You have to be smart about what you're doing. And there's the 30, 60-day rule about having the government having presumption about you making a sort of misrepresentation. And you have to be very careful on this because the consequences are severe. So I would say it's worthwhile to do a consultation with the immigration attorney on that, and just to discuss a particular case scenario. The consequences are so severe. So
Absolutely.
yeah, but thank you for asking it, because it's something that we get a lot of interest in discussion about this.
Yeah, with this option for concurrent filing, I think it just raises the stakes, because we unfortunately could not get advanced parole in the Integrity Act for overseas applicants. And so hopefully that's a policy improvement down the road, especially for people who've been waiting, significant amount of time already, so that they could get started. But that's
right, or even some sort of short-term status because you've been eligible and have been waiting for a certain period of time to come here, and on a temporary basis, and that would be, I think, a huge policy win for EB-5 applicants who are stuck in a backlog. I know, Charlie, you've spoken about that before as a very, I'll say, simple way, but as a way to sort of alleviate some of the harm that is caused by the visa backlog.
So if somebody's overseas, they file 526E, they declare an immigrant intent, are they allowed to come in for temporary travel with ESTA or apply for a B1?
They should always disclose that they have filed an immigrant petition on their DS-160 or when applying for ESTA. And what you want to say when you're making that application is you have the intent to go into the United States for a short-term period, and that if and when your I-526 case is approved, well, then you'll return to your home country and do immigrant visa processing at that time. That's the answer that I think, if accurate, would lead to the best response at the consulate.
Yeah.
Certainly you have to disclose it in your application, because they will check.
They're going to see it.
Yeah, they'll see it. So you gotta disclose that you filed it. We have had clients who have filed I-526s who've gotten B visas afterwards. They've just disclosed it. And it really is up to the consulate. But we've had that happen before. I think it can depend on the officer who's actually looking at the application and potentially your past immigration history. But like I said before, we're really conservative on this aspect of, coming in with the intent to adjust. Mm-hmm. It's always okay for your intent to change later on, but your intent when you come in must be for the purpose of the visa that you're entering with.
Exactly.
And so that's the big key here. And I think it's a tricky area of immigration law because it is somewhat of a gray area. And it is somewhat of a discretionary determination, I think, by the government. They're going to look at the facts, obviously, but there's, let's say you sold a house, right? You sold your house in Canada, and then you come over the border and you take a vacation with your family, and then you go visit your your relatives, and you're like thinking, you know what, this is great. I could really see myself here.
Warm.
And it's a lot warmer here in California than it is in Ottawa. And you decide, hey, and you start learning more about EB-5. You see the concurrent process option, and your intent changes. My intent when I came in was to do this. I'd been working for 20 years in my career. I had built a great, we had a house. The plan was to sell the house, to go take a sabbatical with the family for a few months and travel around the United States. And things changed, right? We decided, you know what, this is the time to make a real change in our life. And now we're deciding to do EB-5. And you know what? You can sell your house for a lot of different reasons back home. It's not because you intended to permanently reside in the United States. Maybe you had someone who made a great offer. Maybe the market was the right time. Maybe you were, planning to do the short-term trip and then coming back home and living with your mom for a couple months and then getting settled down somewhere else and buying a new place. Who knows, right? There's a whole bunch of different stories. But those facts can be manipulated and used in different ways by both a foreign national and USCIS to say, hey, you had immigrant intent or didn't have immigrant intent at that time. So it really is such a case-by-case situation, and it's a tricky one.
Well, I want to, continue on this. We're running over, an hour and 20 minutes now, so we'll want to hit a couple more questions on these strategies before we wrap up. But so on, this discussion of concurrent filing, and for our viewers, we do have some videos on deep dives on the concurrent filing option, but we want to just take this opportunity with Joey and Charlie at Wolfsdorf to kind of get some more insight on this option. Joey's already done a great job explaining some of the considerations and factors that you need to take into account if you're going, how you enter the country, if you're and who is eligible to file for the adjustment of status application and when. And now I just want to talk about a couple of things we've mentioned earlier. And one question was just a very simple question is about child age out and the risks of children aging out. And does filing the I-526 petition and the 485 adjustment of status concurrently have any impact with respect to children aging out or the risk of children aging out?
That's a really great question. So first, let me just clarify. At one point, there was the comment of coming in on an ESTA. You can't do an adjustment of status if you've entered on an ESTA.
Right.
So you wouldn't be eligible to do concurrent filing in that situation. If you came in on a visitor visa and your intent changed and things like that, you are eligible, but not with ESTA. So that was just one thing I wanted to make clear. So with regards to age out and the Child Status Protection Act, there is an argument to be made that filing the 485 at the same time that you file the I-526 freezes the age. When you look at, and that's would be my default position. Mm-hmm. When you look at the plain language of the statute, and what I can see the government coming back on is they say, well, at the time of the approved petition. And so they want to see what is the, it's not the time when you file, it's the time when your I-526E is approved. Then what was the priority date then? What was the child's age at that time? And one of the ways that you can freeze the age is if you seek to acquire within 1 year of a visa becoming available. And I would argue that and one of those ways that you can do that is by filing the adjustment of status application. And so I would say, well, if you've already filed that adjustment of status application, when you file the I-526, then you've frozen it. You've taken the action. The inconsistency, or I guess the gray area, at least the way that I've read it, is that it talks about the approved petition. So that doesn't really make sense to me to have to file another or take another type of action when you've already done what they've wanted you to do. in order to meet the sought to acquire requirement? So I would argue that the answer is yes.
Because
I
it's
don't
actually
know if
the
the government
same action you're taking, even if you were waiting for the I-526 to be approved. Is that right?
exactly.
Yeah.
Exactly. And as long as you do that within 1 year of a visa becoming available, then the age is frozen. Now, it depends on obviously the child's age, how long the case has been pending. But for folks where a visa is current now, again, it doesn't matter as much as what it is at the time of the I-526 approval, but I would still argue there isn't that you have taken action to freeze the age at that time. I don't know, Charlie, we haven't really talked about this, you and I. Your thoughts on that?
No, I kind of agree with you because I liken it to the fact that a priority date is typically the date on which the petition to accord immigrant visa status is filed, not when it's approved, because Congress, when they did that, did not want to penalize the applicant for lengthy processing times. So, I could file my petition for status today, but it's not approved for 6 or 8 months. So they didn't want me to be penalized for that 6 or 8 month delay. So that's where I totally agree with you that it would seem reasonable that I file a concurrent filing today, that I should lock in my age as of today.
Yeah, it's a tough one. I mean, it doesn't seem to make sense why you would be, why it would be to your detriment to do a concurrent filing when it's allowed, and why USCIS would require you to do a separate unnecessary filing upon approval. It seems like it just doesn't make logical sense to me why they would want that.
One of the reasons behind the establishment of the Child Status Protection Act was because of lengthy processing delays on cases where people were aging out. So, again, there are lengthy processing delays in play now. So why would they want applicants to be penalized? Because of those lengthy delays and not timely action on cases.
Could future retrogression impact the protection of a child's age? Beyond just how long it takes to actually do the work.
Yes, it can. Oh boy, we're getting deep into the Child Status Protection Act. I don't know enough. Charlie, do you remember how it works? I know there's something you have to. If it retrogresses, you have to take some sort of action to lock it in within a certain amount of time.
Luckily I was able to avoid much dealing with this Child Status Protection Act. It is kind of a convoluted process, and I would not want to risk misstating the situation.
Yeah, I don't want to shoot from the hip either. I do know that Bernie is an expert when it comes to the Child Status Protection Act, and we have done a lot of work and research and written a lot of briefs because it is confusing, and USCIS is confused on it as well, and so does the State Department. It's not always something easy to understand. So we're certainly happy to look at it and be able to advise on whether there would be an age out. Retrogression. I think it does matter. I think it does matter on if you've already filed that adjustment application. I think there is some impact there. Yeah.
And there may be information on this issue on the State Department's travel.state.gov website. Often that site has clarification on issues such as this, and there may be something there.
Well, I would ask then,
so here,
on
if
the concurrent filing, then we can switch to something that is coming up often for folks in the United States and looking to file the adjustment of status concurrently with the EB-5 petition, and that's this 245K waiver. And so can we explain what that means and how that can be a benefit for potential EB-5 investor applicants?
Absolutely. So before, so the INA 245K waiver pretty much allows there to be certain non-immigrant visa status violations that would have otherwise barred you from filing for an adjustment are waived. And before, this was available for other EB1, EB2, EB3, potentially EB4. I'm not sure, maybe not, but it was never available for EB-5 until the Reform and Integrity Act. And so now you can have, I believe it's up to 180 days of out of status or unauthorized work since your most recent entry into the United States and still be eligible to file for an adjustment of status. A year ago, if you had 1 day out of status, or 1 day of unauthorized work. So let's say you were a student, right? And you did EB-5 and it was current, but you had a day, you worked at a sandwich shop for a weekend, right? And it wasn't part of your OPT or whatever it was. You didn't have your EAD, then you technically would be ineligible to file for an adjustment of status. Now that is waived under this 245K protection. So that is another big benefit that comes to EB-5 investors in the United States who now have this opportunity to file the concurrent processing. Yeah, that's a big one. And
That's
I know
huge.
there's some folks who, yeah, that's huge. I know there were some folks who, were in the United States, couldn't do the adjustment, were waiting for the I-526 approved to do consular
Hmm.
processing abroad, and then this law came into play, and then they filed the adjustment. And since then, I know that they've gotten their EADs
Okay.
and they've gotten their advanced, I think they're going to be getting their advanced paroles soon. So, the benefit is clear, and USCIS knows that it applies for EB-5 investors, and for both pending and for new ones.
No, it's a fantastic option, and it's necessary, as you described it, for some people.
Yeah, I mean, I had someone I was just talking earlier this week about a guy who was here on an F1. He had he worked for over 180 days, and we were always saying, well, you can't do your adjustment. And he has since left and re-entered, and he got a new H-1B stamp, and so it's from your most recent entry. And he hasn't had any unauthorized work, so it shouldn't be an issue in his case, but it is definitely something that comes up all the time. So yeah, it's another important aspect from the new legislation. The only other thing that I was sort of thinking about was potentially, if you want to, I don't know if you guys are even accepting this, but actively in the process of investing to get your spot in the waiting line
Yeah.
with a priority date could be another thing. But
Yeah, sure. So I mean, we can highlight that. Again, with this some uncertainty in the future in terms of when our final action date is going to be implemented, how many visas are going to be processed and how many visas are going to be carried over. It does behoove people to file early to get in, get their priority dates early, as Charlie mentioned earlier. But sometimes people don't have the full 800,000 assembled. They don't have the cash in the United States or able to be transferred to the United States. Are there any other strategies that investors have to be able to move forward so that they can file concurrently, get the EAD started, and get this process going while still having some time to be able to assemble that full $800,000 investment required for EB-5?
The answer is yes, because the requirements are that you have invested or are actively in the process of investing the minimum investment amount. And so we have had cases approved where an investor puts in an initial sum of, say, $100,000 or $200,000, and with the full source of funds for that initial investment, as well as a commitment letter saying, hey, I'm going to fund the balance of the investment in 6 months or in 12 months. And and to identify the sources of that, I have this property that I've put on sale. Here's the appraisal value. Once I sell it, the proceeds from that sale are going to be used in part to pay the balance of the EB-5 investment, right? And then once that sale goes through and you have the money, you interfile, And interfile means you're pretty much updating the file
Yeah.
with USCIS. They're not required to accept that. They normally do, though. And if not, they'll just issue a request for evidence. But in this sense, you get your initial filing in because you've made your investment and you're actively in the process of investing. And I just got a case approved last year where they just did this. It was at the 500K investment. It was a lady. She put in 200K. 6 months later, she put in the other 300K. We interfiled. They didn't get the interfile, so they issued an RFE. We had to resend in all of the same documents over again, and it was approved. It was a non-issue. I mean, it's built into the law. There are some changes now where you have to make sure that you're within the legislation where you have to make sure that your investment is now completed before they approve your I-526. I believe that's what it is, something along those lines. So you need to get it in much earlier on now than you did. But best practice, what I always recommended was no more than 12 months. You want to show the government that you are committed to making the investment. It's just there is a timing issue at place, and there's nothing wrong in moving forward with what we call partial investment to secure your line and to get that earlier priority date.
It's funny you say that because it's almost like preponderance of the evidence means all the money has to be in the account by the time they pick up the file, where actively in the process is more of a judgment. But yeah, I think in practice that makes a lot of sense. You just be proactive, get it all in there before it gets to the adjudicator.
Yeah, and for our viewers, I mean, we do have a deep dive video on the partial investment approach, so you can check out that video
perfect.
in detail. But at Bearing, we've had a lot of success, probably since 2017, with partial filings. It does need to be done carefully and properly to demonstrate your commitment, to the investment and show, as Greg mentioned, that you're actively in the process of investing. But with an attorney like Joey, it can be crafted properly, and as long as you're doing it within that time period, you can be successful. It could be a successful strategy just to get started, especially for folks now if they're in that 60-day grace period. If they've unfortunately have been laid off in the H-1B field, or they're looking at that timing of the 180-day waiver period under the 245K waiver that we were just talking about, or any other type of deadline, any type of sense of urgency. That partial approach can be an effective strategy because you just have less documentation at the time of filing, and then you interfile the rest later. But it does need to be done in careful consultation with your immigration lawyer.
Well, thanks. I think there was a lot of good stuff here. It kind of went by quickly.
Goes fast.
It was easier than I thought it was going to be honest. I was a little nervous for this, but it worked out.
There's so many
nicely.
questions, and we can go into so much detail. I mean, you guys offer a lot of great insight, and I should just say thank you properly to Joey Barnett and to Charlie Oppenheim of WR Immigration for taking their time out today to walk us through the intricacies of the visa bulletin, visa numbers, visa set-asides, you name it, concurrent filing, and other strategies that EB-5 investors, both existing and potential EB-5 investors, need to consider when taking this path. It can be a successful path, and it can be a fast path comparative to other routes. But it's a long-term commitment, and it just needs to be done properly, carefully, and with a good team. And so we just appreciate, again, your time and your thoughts today.
Well, it's our absolute pleasure to be here, and we thank you guys for pushing the EB-5 industry forward over the past 18 months or so. And as we continue to shape and sort of live in this new era of EB-5, it's a fun time to be in it. That's for sure. So thank you guys.
Yeah, excellent. Yeah. So folks, if you want to hear more from Joey and Charlie at WR Immigration, I think it's wolfsdorf.com is the website for WR Immigration Law
Yep.
Firm. And of course, if you're interested in talking from a former IPO officer here at Baring, Greg or myself, BaringEB5.com, and we'd be happy to speak with you and help you understand more about the EB-5 process. Thanks, guys.